Okay. Uh, how are you guys doing? Um, I have three little slides I want to kind of go over, and then we can certainly take questions. And feel free to either raise your hand or unmute yourself because we have a small group today. It is a holiday, but I wanted to go ahead and do the broker chat today, regardless. So this is just three little slides. But what I wanted to do is kind of get the word out, and I'll be talking about this again at different sales meetings and what have you, of really what it means legally to structure listings with either the gross payment method, where the seller is agreeing to pay a gross amount to the listing broker, which is being shared with a buyer broker, versus the separate pay method, and what that really means from a broad perspective legally. And it has taken me some time, I'll be very honest with you, to get my mind wrapped around it. And I've had to have some lengthy conversations with the Georgia Association of Realtor Attorneys about it so that I can fully or better understand it. So I'm just going to go ahead and give you kind of a comparison real quick. And then if along the way you have a question, don't hesitate to chime in. This is supposed to be an interactive call. So feel free to chime in with any questions that you might have. So right out of the gate, if you're doing the gross pay method here on the left, you'll see the gross pay method, and it says that the seller is contractually obligated to pay the gross compensation, which can include a buyer broker compensation. So whatever they're saying is the gross pay method, if there is a buyer brokerage compensation, that is what they owe at the end of the day if that listing broker sells their listing. The question of whether that amount that was advertised to the buyer broker gets paid to the buyer broker is going to boil down to, was there actually a buyer broker involved or not? Because arguably, if there wasn't a buyer broker involved, then the seller could still owe the gross amount. If there is a question of procuring cause of sale and things like that, then that's a separate issue. So if there's no buyer broker, seller still owes the amount of the gross compensation or whatever is stipulated if that amount is being reduced. Listing broker has to accurately advertise what the seller agreed in the seller brokerage agreement, also known as the listing agreement, to share with a buyer broker if one procures a buyer, plus any strings that are attached to that. I'm going to show you some examples of how this is structured in a moment, but they have to advertise the amount of compensation being offered to a buyer's broker, and if there's any strings attached to it, such as circumstances for which that amount would change, such as, for example, seller's broker shows property to the buyer prior to the buyer broker showing the property, that sort of thing, then the amount will be blank. And if there's a dispute between the two brokers, seller's broker and buyer's broker, regarding the amount of compensation or whether the buyer's broker procured cause of sale and is owed any compensation at all, then that dispute could be handled through the Board of Realtors, broker to broker, through an arbitration. So basically everything on the left is pretty much run-of-the-mill, the same language that we've been dealing with for decades in our listing agreements, and is very much the same, works the same, and has the same legal teeth to it and options available. When we go here to the side, the right side, where it's the separate pay method, this is what's really changed as far as our listing agreements go, and this is a new option for listing agents and sellers. And this is separate pay method of compensation, where the listing agreement can be structured such that the seller pays each broker separately. It definitely changes things, good and bad. It just depends on which side of the fence you're on, for both brokers. So number one, seller's broker is authorized to advertise the amount if any of the seller is willing to pay the buyer's broker. So you have to advertise whatever the seller has agreed that you can advertise in the separate pay method. However, there's a catch. If there's no buyer's broker in the transaction, seller will only owe the seller's broker the amount referenced to be paid directly to the seller's broker. In other words, they're not going to owe any portion of that buyer broker commission, they'll only owe what they agreed to pay their broker, which is the seller's broker, and not any portion of the buyer broker's commission. But of course, there's a special stip that I recommend that I'm going to show you an example of, where if you, as the seller's broker, were having to do additional work for an unrepresented buyer, you could stipulate that your amount that the seller pays would increase by a certain percentage. Seller, this is the biggie. Paragraph 3, seller is not legally or contractually obligated to pay the amount referenced in the seller's brokerage engagement agreement to buyer's broker until or unless seller signs a document with buyer's broker agreeing to pay them. That would be the F-258, which is the pre-showing compensation doc, which requires sellers to sign. And this is one of the primary reasons why it requires the sellers to sign in the event that there's a separate pay method, or the F-259 compensation exhibit that is now optional and can be a part of our purchase and sale. And again, seller has to sign, or the F-255 instructions to closing attorney. That would be the weakest of the three forms, but nevertheless, it would be helpful because the seller is also required to sign, and that is instructing the closing attorney that they are agreeing to have that amount deducted from their proceeds. So that all three of those are options that actually they contain both the seller and the buyer's broker's signatures. So that's huge because on the seller's brokerage engagement, also known as the listing agreement, that buyer broker signature is not on it, never will be on it. So with a separate pay method, until you have a seller signature on the F-258, F-259, or F-255, where you've got buyer broker and seller signing a document saying this is what seller will pay you, you really, as a buyer broker, don't have any contractual obligation from that seller. And paragraph 4, if the agreement, above agreement 258, 259, or 255 is signed between the buyer broker, of course, the seller's broker signatures on there as well, and the seller has agreed to pay X percentage of the purchase price or X dollars to a buyer broker, then if the seller were to then at the 11th hour refuse to pay or state they're not going to pay or whatever, then unfortunately, because this would be an issue between the buyer's broker and a seller rather than a realtor and a realtor, such as the two agents going to the board of realtors to arbitrate over the matter, they're the only option for a buyer's broker to try and collect that from the seller would be to sue them in magistrate court, depending on the amount, or in superior court, or private arbitration, but not through the board of realtors. So again, that's a game changer if you're a buyer agent. If you're a listing agent, you may say, hey, and there are some brokerages out there, they're saying, hey, we want our agents to structure separate pay methods because we don't want to deal with ever being drug into an arbitration over procuring cause of sale again. So this way, if we have a situation where our seller refuses to pay or whatever, or is trying to negotiate that amount at the 11th hour and this and this and this, we are just kind of the communication person, but we're not in the middle of it. And it's really going to boil down to being between the seller and the buyer broker. And we're legally kind of out of it, other than just helping to communicate that agreement between them. But we're not in charge of it and we're not enforcing it. And if seller doesn't honor it, we're not liable and we're not going to get drug into arbitration. Any comments or questions about those epiphanies so far? Feel free to unmute yourself. No? Okay. All right. If you want to unmute at any time and interject, that's fine. I'm going to show you actually what they look like. So here's your a clip of the compensation paragraph from your GAR F-101 exclusive seller brokerage engagement agreement. And this is the gross pay and share method. And so in this one, you've got your higher amount at the top in section 4B. This is a higher amount because it's going to encompass both brokers' compensation in one lump sum. And if the seller has agreed to pay that, then the seller has agreed to pay that. And that's what they owe at the end of the day if the listing closes with this listing broker. And if there is no buyer broker, then they still owe the full gross amount unless otherwise stipulated. So I'm going to show you that in a second. You have to specify the amount that you're able to advertise that you're going to agree to pay and share as the listing broker with a buyer broker in section C. And you have to disclose by checking the second box under C, which says seller's broker out of the compensation being paid. In other words, that's where you're acknowledging that the amount above is a gross amount that will be shared. And then you put the amount that will be shared. And then if there's any strings attached to that, such as if seller's agent shows property to buyer before buyer's agent shows the property, the buyer broker compensation will be 1.5% of the purchase price. Then in the box below, where you'll see I have it highlighted in the box check, that's where you would specify any special circumstances. Now, if you're going to advertise this, wherever you advertise it, whether it be your private website, whether it be the F-258 pre-showing compensation, you need to advertise accurately, not only what the seller has agreed you can share with a buyer broker, but any strings that are attached to that. So if there's any conditions for which that amount will change, you have to advertise both. The amount that the seller has agreed, as well as what they've agreed it can be changed to in the event those circumstances occur. Now, in lots of cases, when I've been teaching this class, a lot of agents have brought this up. They've been doing this gross method for decades. This has been really the way we structured our commissions for the most part. It was a gross method. So if there was a buyer brokerage compensation being offered, which was always optional, then that was lumped into the gross amount and then agreed to be shared. However, a lot of agents found it very helpful, and I agree because I used to do the same thing, that if you're trying to have this conversation with a seller and the question comes up, well, what if you sell it yourself? You know, it's yes, you're having to do additional work if you have an unrepresented buyer, but the unrepresented buyer is not a client. So you're doing basically ministerial acts and facilitating. So in order to kind of strike that win-win situation with the seller, a special stip saying in that event, seller, where I'm actually doing extra work because there is this buyer that needs me to facilitate and do these ministerial acts for them, but they're not my client, then the gross method will be reduced so that you don't pay quite as much. And it's a win-win situation. And you as the listing agent actually make more than you would make if there was a buyer agent. So if you look at the very bottom of this slide, it says a special stip, and I would like you guys to add this to the special stip section of the exclusive seller brokerage engagement and not to the commission paragraph. It really needs to be in the special stips. And it says if no buyer broker procures the buyer for the property and seller's broker is not required to share any portion of gross commission, then gross commission shall be reduced to 4.5% of the sales price. These percentages are put into this example, this training example, simply to give you guys some substantive example of how to fill this in. Nobody is committed to abide by these percentages or use this exact language at all. I'm just trying to give you guys some sort of takeaway so that you can get the concept of how it would all work mathematically. So let's look at the same paragraph, but with the separate pay method. Okay, so this is the same paragraph of the GAR F-101 exclusive seller brokerage agreement. And this is done with a structure with separate pay by seller, paying each broker separately. So in section 4B, I've put just the amount that the seller's broker will receive from the seller when the property sells. And then in the optional section C, I've put just the amount that the buyer broker, the seller's authorizing to be advertised to a buyer broker, and that's very important. They're not actually obligated to stick to this number just yet, but you as the seller's broker is obligated to advertise what the seller told you to advertise, which is this percentage that you have here in 4C. You have to disclose that it is a separate pay method. So that's where you mark the first box under paragraph C that says seller will be paying that buyer broker directly, in addition to the compensation that they've agreed to pay their broker in paragraph 4B above. Now, when you're advertising this, if there's any strings attached to it, then you need to specify what those conditions would be, and you need to also state the amount that would alter that advertised percentage to the buyer broker. And that again would be in the special circumstances blank, where I have that bottom section of paragraph 4 checked and it highlighted, saying that if seller's agent shows property to buyer before buyer's agent shows the property, buyer's broker compensation will be 1.5%, etc. Lastly, we have the same scenario. Well, what happens if I'm representing the seller and I'm doing the separate pay method? Then there's no buyer's broker. I'm technically only going to get the 3% that's in 4B, but I'm going to have to do more work, because that underrepresented buyer is going to need me to kind of hold their hand and babysit them through the transaction, provide all the forms, write up all the amendments, write up all the documents, etc. So in that instance, we're going to put a special stip to accommodate that. It doesn't say the word increase the compensation, it just states the amount, but basically what it's doing is the exact opposite of what the special stip in the gross pay method did. So in my little special stip at the bottom, it says, if no buyer broker procures a buyer for the property and seller's broker is assisting the unrepresented buyer as a customer performing ministerial tasks, then seller's broker compensation shall be 4.5% of the sales price. So you're taking that 3% of the sales price that you have referenced in 4B in the event that there is no buyer broker, and you're raising it up to 4.5% to accommodate for the additional work you have to do for that unrepresented buyer that you have to perform ministerial tasks for and their customer. So that's your two comparisons. And then, of course, back here, side by side, we have kind of the pros and cons. If you are the buyer's agent, then you should certainly hope that the gross method of compensation has been done by the listing agent, because not only does it give you arbitration rights if there's any kind of dispute over procuring cause of sale, but also the seller has contractually agreed and is committed to whatever they agreed to pay on the gross commission. The only argument is the sharing of the portion and whether you procured cause of sale or not, and whether the listing broker is going to share what the seller said that they could share, or a lesser amount, for example. So that's definitely going to give you a lot more protection if you're the buyer agent on multiple different levels. Whereas over here in the separate pay method, where the seller is paying directly, if the seller refuses to pay, then the broker for the buyer has to actually pursue that legally directly from the seller, and you really don't have anything that you can really sink your teeth into legally as the buyer broker based on just that listing agreement, like you would in the gross pay method. With the separate pay method, until there's a document that contains buyer broker signature, seller signature, and of course listing broker signature, which would be the F-258, 259, or 255, all of which now require seller signature, then you really don't have anything legally that you could go to a judge and say, this is the written document where seller agreed to pay me, I signed it, seller signed it, and they agreed to pay me, the buyer broker, this amount of money. Okay, please unmute anybody or raise your hand, whichever you prefer, and go ahead and ask some questions, comments. I'm really anxious to hear what you guys think about this, which method you prefer, all of the above.
Hey Angie, it's Patrick Walters.
Hey, Patrick.
Hi, I came in on tail end and I just wanted to clarify on the gross payment method.
Okay.
Um, is the buyer broker, is it required that the buyer broker and the seller sign something to obligate the seller to pay the buyer broker?
No, no, it's
Only
not.
on that's only on
Only
the
on the
set.
separate pay method.
Got it. Okay, thank you.
And at the bottom of the F-255, F-259, and F-258, it says that only if seller is doing a direct pay to buyer broker is seller required to sign. Because
Okay, thank you.
with the gross payment method, the 6% is a gross amount, and seller is paying that regardless. And technically, if there's no special stip like the one I have here that you're looking at the bottom of this screen, that reduces that amount, if no buyer broker procures a buyer for the property and there is no buyer broker, seller's still stuck paying that gross, in this example, 6%. And then, but if you are the buyer agent that procures the buyer, then the seller has said 3% of that 6% goes to that buyer broker. So this document with the gross method really does help protect that buyer broker compensation. It does that job. The other method, this listing agreement does not do that job. And that was an aha moment for me, because I felt like if you've got this other method where you've got a seller saying, go ahead and advertise that I'll offer, this is the separate pay method, 3% compensation of buyer broker. I thought that meant something. According to the attorneys for Weissman, it actually kind of doesn't mean anything until they go to the next level and actually sign something contractually with that buyer broker, F-255, 258, or 259.
Got it. I in my experience so far, with the buyer broker not having visibility to that listing agreement, they get kind of nervous as to whether or not you actually have that in place with the seller.
Correct. That's
So,
why it asked the question in the F-258. It asked the question for them to disclose that. And but the problem is a lot of agents aren't disclosing things accurately, or they don't themselves even fully understand. So they're supposed to disclose, there's a checkbox where they disclose that it's the gross method that they've negotiated in their listing or the separate pay method. But as your backup, and I'm just telling you guys what we anticipate, the forms committee, according to, and the attorneys and different people that are working on these things, that we are all anticipating that we're going to see it more and more included in the purchase and sale. And so when in doubt, you use your F-259 exhibit and you include it as a part of the purchase and sale. And I think we're going to start seeing more and more of that, because ultimately the seller is signing that purchase and sale.
Angie, are we gonna get a copy of this?
I can certainly send that to you, Brenda.
Please, thank you.
Uh-huh. And I don't know if Stephen, he might not have the link. I wasn't sure, but I can certainly send that to you, Brenda, no problem. And I know it's being recorded. So, anybody have any more questions or comments? My little unofficial poll among agents is that the vast majority of agents, and it's possible because it's familiar to them, they're still, listing agents I've talked to are still using the gross pay method because that's familiar to them. But there are entire brokerages that are actually training their agents because they don't want to be hassled with arbitrations and they don't want to be involved. So they are actually setting policies to have their listing agents do the separate pay method, which is the example we're looking at on this screen. And so, again, this has only been road tested for a few months now. And, as we dig in and get more used to our new procedures surrounding compensation, it will be interesting to see how things evolve. But I would definitely say, when in doubt, the F-259 exhibit or the GAR Special Stip 620, which is a special stip where you can ask for, and do not, under any circumstances, please, because it could be very problematic. There's a lot of legality surrounding asking for compensation. Do not write your own special stipulation. If you're going to ask for buyer broker compensation to be paid by a seller, use the GAR Special Stip 620. Do not write your own, or use the GAR F-259 broker compensation exhibit. And just a little FYI for you guys, that F-259 is going to get retitled and reformatted for 2025. And in January, you will see it called the buyer broker compensation exhibit, and it's not going to have any reference to the seller's broker compensation. So that's going to make it easier for you guys as buyer agents when you put together an offer to fill it out, because you're not going to have to put the listing broker's compensation in it, because that's been established very clearly between that listing broker, aka seller's broker, and the seller in their listing agreement, which is the way it's always been for decades, since any of us can remember. So so that is going to be a good change as far as you guys as buyer agents working with that exhibit, the F-259. Any more questions or comments? Love it, hate it? What do you prefer? Can you see the pros and cons in both?
I had a question, Angie. This is Carlin from Midtown.
Yes.
I am still seeing in the FMLS quite frequently, not all the time, that agents are still putting in a buyer's compensation. I mean, putting it in the actual listing, just in the FMLS.
Because
Can I? I mean, I wouldn't, but
right.
But can I? I mean, do I just need to go through this process as if I didn't see that number, or is there any leg to stand on if I see that?
I would still go through the process, Carlin, because
Okay.
you know, even though FMLS is not a broker, it's a broker-owned MLS, not a realtor-owned MLS. So they do not have to abide by the terms of the NAR settlement. So, however, many of the brokers that are members of FMLS, including us, feel that it's the best policy to not offer the compensation, but you can make a link as long as there's a two-click rule. As you can offer a link to a website, and you can offer directions on where people can receive a copy of the F-258, the pre-showing compensation doc. You cannot, however, upload that compensation doc as a doc on FMLS, but you can make a reference that, you know, go to this website or whatever, or this Google Sheet to obtain a copy of the pre-showing compensation doc. But actually advertising it, we are being abundantly cautious as brokers not to have our licensees do that. And then the two-click rule would mean that when they click on, for example, a website, they would have to click on a page, a second page, and make a second click to be able to actually see the compensation for that listing. But I would still not take that to the bank because that is not a contract. That is advertising, and it is not a contract. And so in this climate, it's all about the agreements that are in writing. So I would absolutely want to get that F-258 signed and still show the property regardless.
Right.
Or if you don't get the F-258 signed and get that clear, or you're not feeling warm and fuzzy about it, then, you know, you have information that they've advertised, fantastic. Then just go ahead and include the F-259 exhibit in your offer, which you shouldn't push back for because they're already quote unquote advertising it.
Right. Excellent. Thank you so much. I appreciate that.
Of course. What do you guys think? Can you see the pros and cons in both? The cons for the separate pay method, there's some pros, I think, for listing agents as far as less hassle, less legality, less babysitting for me. But there's some certainly big cons for buyer agents if a listing broker is doing the separate pay method. Because you just can't take it to the bank until you get something with that seller's signature. And fortunately now with our F-258, F-259, and F-255 all requiring the seller's signature if there's a separate pay going on, that's gonna at least give something that has never existed before, which is that little three-party triangle agreement with somebody else's client, in this case, the seller, saying you're going to pay this buyer broker. Whereas up till now, we've had no such document where a buyer broker and a seller ever signed anything that was any kind of agreement between them. So that's a big game changer. Anybody on the call, a listing agent? And if so, what are you structuring your seller brokerage agreements? How are you structuring them? No, hold on.
Angie, may I ask a question?
Yes, Brenda.
All right, I haven't done it.
Hold on, Brenda. I accidentally muted you. I was trying to unmute you and I
I'm
muted you.
I'm sorry.
Okay.
Okay, since I've been out, I'm recovering from surgery, I haven't done any of this. So I'm just, listening and learning. But in the event I took a listing or when I take a listing, I understand everything needs to be disclosed. Prefer everything be clear about how I get paid and what the seller pays. Is there ever an appropriate place to put on either of these agreements that compensation is paid based upon appraised uh, value of property if it's a situation where the buyer's getting a loan?
Um, that would be more of the separate pay method, which is the screen that you're looking at now.
Okay.
And you would have to, I'm not a big fan of that, neither is Tom, our qualifying broker.
Okay.
But could a seller do what the seller wants to do? It would have to be done with this separate pay method. And my advice would be that you would put the amount in section C as 0 buyer broker compensation. And then you would indicate in your advertising that it's negotiable, just like closing costs or anything else, and not offer up a specific amount. And then let it be fully negotiable. But I would put in a dollar amount here, nor would I offer up any advertising of a dollar amount, but I can guarantee you would definitely need to do the separate pay method so that you would check under 4C, the second box, and you would just to indicate that it's a separate pay method, and you would put $0 or 0%, and then you would advertise that it is negotiable. And that would be kind of like, just like, and you got to be careful, like advertising, even if you have written permission, because you can't go quoting numbers if you don't have written permission from your seller to quote those numbers. For example, if you have now the seller concession field, well, seller concessions could be anything. Typically, that's thought of as the closing costs contribution that a seller is offering to pay. One does not need to assume that that means that it's buyer broker compensation. So the seller concession field, if you go ahead and say seller's willing to pay blanks in seller's concession, well, they may not really want to do that if the offer comes in as an extreme low ball, or like you said, Brenda, it appraises really low. So sometimes you don't really want to necessarily advertise if that's really a big question mark for the seller, you don't want to commit yourself to any kind of dollar amount or the seller to any kind of dollar amount. You just want to say it's negotiable. Like anything else in the contract, if they would make whatever offer price or whatever, asking for whatever closing costs. And if an appraisal does come in low and somebody, and this is just general rule of thumb, seller is never required to amend the purchase price. The risk they take is if they don't amend the purchase price to lower it in the event of a low appraisal, that the buyer will exercise their right to terminate because the seller would agree to lower the price. However, if I'm the seller and you're asking me to lower the price $20,000 because of the appraised value, and maybe I was giving $10,000 in closing costs, I realize the whole deal could blow up and you might terminate as a result, but this is affecting my net and you're asking me to do something. I can say, I'll do what you're asking me to do and lower the price, but I'm also going to take away or lower those closing costs that I previously agreed to, because this is an amendment and you want me to amend something that affects my net, then I'm going to counter back and say, I'm going to lower it here and I'm going to take away those closing costs. And again, at the end of the day, if that can't get agreed to, seller's not in default for not agreeing, and buyer's not in default because they would be able to exercise the right to terminate. But it's something that the seller does have the power to come back and at least attempt to negotiate.
Okay, now let's say I've listed the property, and I'm sorry, there's noise in the background here, but hopefully you can hear me.
I can.
Okay, negotiate a selling commission, a listing commission, and then at the same time, I want to give myself the flexibility to earn a buyer's commission should a buyer come along. Uh, so at that time, would you recommend using the two separate forms, uh, or separate forms? One saying, if I'm acting as your selling agent, then this is the amount we prefer, or I prefer. And I want to protect that amount as much as possible. If you will, tell me what form to use. And then
There
if a
would be,
buyer comes along, and then if a buyer
are you
comes
talking about
along,
an unrepresented buyer?
right, and I'm a represented buyer
Okay,
comes
then you
along.
would just use
Okay.
your special stip, or I would use your special stip. Right here in the example, Brenda, you would use the gross pay method. You don't need two separate forms because the buyer is not going to be a client, they're going to be a customer, and you don't need the buyer to sign anything in order to see your listing. You just would mark on the front of your purchase and sale in paragraph 10 that the broker is representing the buyer, and check the second box to say that they're a customer. And the way you'd protect that commission would be to use the gross pay method. So you would use, for example, 6% gross pay, and then at the bottom, you don't have to use the special stip that says that if an unrepresented buyer comes along, that amount would be reduced to 4.5. You can just leave it as 6%. And if an unrepresented buyer comes along and there's no buyer broker that is representing that unrepresented buyer, you'd get the full 6%.
Okay. In
Buyer
the
broker,
event I list the property, I didn't have a buyer in mind at the time. The buyer had not shown up, but
right?
then a buyer shows up and I
Right.
get them under a buyer brokerage
You would
agreement.
not do that. You would not do that if that buyer buys your listing, because then you'll be a dual agent. Only if that buyer is not buying your listing, and then that's a separate transaction altogether. So you never want to sign a buyer brokerage agreement with that buyer to buy your own listing, because then you'll be a dual agent. And we really do not, even though it's not illegal, we do not want you guys to be dual agents, because money and agency are two different things, and it's just a lawsuit waiting to happen.
Okay, now
And
last
just do the
question.
gross method.
Okay, last question. I didn't know this buyer was going to like the listing. All I did was I got a buyer. I put him under a buyer brokerage. It just so happened they liked my listing. So do I
Okay.
refer this to a different agent?
Nope. That
Nope.
actually, that scenario that you're talking about, which is unusual, but it does happen, where you have a buyer brokerage agreement that already exists, and sometimes you don't even have the listing yet, and then the buyer's looking and looking and looking, and then you end up getting this listing and it ends up being the perfect property for the buyer. You are then automatically a dual agent. And in that case, you need to specify which client is paying what money. So in that case, they both have to consent, and you probably have to do an amendment to your brokerage agreement to say that they're both consenting to dual agency. And then you could be a dual agent in that case because you were already representing the buyer first, and then the buyer wanted to buy your listing. We would allow that, but we would want you to email us and let us know that you're doing it, and we'd want to help guide you to make sure it's done correctly. And under license law, it says that you have to specify who is paying what commission. Because, for example, if you have 6% gross commission and then 3% that the seller's going to share with a buyer broker, then you are the buyer broker. Then you've also got the buyer brokerage agreement. You just need to clarify, since you have two brokerage agreements, both obligating parties to pay money, you need to clarify in the purchase and sale who is going to pay what. And that's a license law requirement.
Thank you.
You're welcome. That doesn't happen often, but it does happen on occasion, especially when the market is low inventory. Any more questions, thoughts, comments? Do we have any listing agents that want to share what they prefer doing or what they think is the best method? Okay, guys. Well, let's see. Guess that's pretty much all I wanted to discuss with you guys today. I thought it was going to be more of a hot button subject. I've talked to a couple agents about this, and they have found it very helpful and interesting because they had not looked at it from this perspective before. But I think it's definitely something we need to be educated about. Definitely not only as a listing agent, but as the buyer's agent. If you're going to go out there, you've got to understand the big picture ramifications of a separate pay method and how important it is to get that secured in writing with a signature from the seller in one of those docs, the F-258, the F-259, or the F-255. So, okay, I'm going to go ahead and wrap it up, and we're going to jump in to the, in 15 minutes, I'm going to start the Contracts 101 Part 3. This is going to be a look at the exhibits that go with your typical purchase and sale transaction. So it's going to be kind of a deep dive into the financing and appraisal contingencies, including the FHA and VA appraisal contingency language and changes that were made to those in early 2024 that a lot of agents still aren't aware of. So we're going to be talking about that, as well as the temporary occupancy agreement. So all of that is starting at 1. And so if you guys want to rejoin the Zoom, same link at 1 o'clock, we'll be starting up for the Contracts 101 weekly presentation that we do. And again, this is part 3 of the 4-part series, and it is the exhibits, specifically financing, or loan exhibits, I should say, financing and appraisal contingencies, as well as the temporary occupancy agreement, and how best to functionally use all of those. So I will go ahead and sign off, and then I will see you guys, whoever wants to join me, I will see you in about 15 minutes. Thank you.
Thank you,
Thanks,
Angie.
Angie.
Thanks.
Lots of information. Thank you.
Thank you.